Today we're talking about what a trial in a criminal case actually involves. If you're involved in a criminal case in court and you've chosen to challenge or to contest the charges against you, your case will move towards a trial being conducted. The purpose of conducting a trial is to allow the court to review the relevant evidence and decide whether you're guilty of the charges brought against you. During the trial, the judge will see and review the evidence produced by you and the prosecution, and this evidence can then be presented in the form of witness testimonies, documents, videos, photographs, and also physical objects. The judge will try to find out the truth of what actually happened by assessing the accuracy and the credibility of the evidence presented. After hearing all the evidence presented, the judge will then decide whether to convict or to acquit you. How should you then prepare for a trial? The judge can only consider evidence presented in court during the trial, and whatever is not presented before the court cannot be considered. You must therefore bring along all the evidence, including witnesses, if any, in support of your defense at the trial. Both sides have a right to call witnesses, and all witnesses will be sworn and affirmed under oath and will be subjected to questioning by you and the prosecution. If you want to rely on what someone else says or knows, that person must actually come to court so that the prosecutor will be able to ask him questions. Regarding your witnesses, you must remember to make sure that all your witnesses turn up for the trial. If you're not sure whether the witnesses are willing to turn up, you should apply at the crime registry in the state courts for something called a summons to a witness. This can be issued against that person, and a fee is payable for every summons issued. A court process server will then help you serve that document on the witness. Regarding your documents, you must prepare the documents and all the evidence that you plan to rely on for your defense. You need to prepare at least 4 copies of the documents. One, the original, is for the court, 1 copy is for the prosecution, another is for the witness, and 1 is for yourself. You should know that documents such as WhatsApp or Facebook messages can also be presented as evidence in court, but this is subject to the court's decision. As a general rule, you should also ensure that the person who made or created the document is in court to explain and confirm how it was actually made. Otherwise, the document will possibly be rejected and will not be allowed to be admitted as evidence for the trial. Your documents should be prepared well in advance before the trial. This is very important because the court can order you and the prosecution to submit these documents before the actual trial date. Regarding your preparation for the trial, you should remember to prepare a list of the questions that you want to ask to your own witnesses and the prosecution's witnesses. Regarding the admitting of documents and photographs for the trial, you should know that both sides are allowed to show the judge documents, photographs, videos, reports, and objects as evidence. If you want the judge to think through and consider any document or evidence presented, you should prepare copies of it and bring the original to court. The maker of the document or the person who took the photograph or created the document should come to court. Otherwise, the court may not review it or accept it. You should introduce the documents and photographs through the relevant witnesses by asking the witness to tell the court during the examination in chief. So here's a very quick reminder and summary of what you need to do to prepare for your trial. You need to bring your evidence to court. You need to have original copies of each document to be used as evidence. You need to ensure that the creator or the maker of the document comes to court. Otherwise, the document may not be considered as evidence. You need to contact witnesses in advance and ask them to attend court for the trial. You need to make sure all your witnesses actually attend the trial, and you need to apply for a court order called a summons to a witness, telling your witnesses and reminding them to attend the trial. So, there you have it, some very basic information on what a trial in a criminal case involves. Thanks for watching.